Good afternoon. We reconvene the fifth meeting and fourth public hearing of the Special Committee of the Senate on Sexual Offences Amendment Bill 2019. This hearing is being broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel ParlView. My name is Clarence Rambarat. I'm the chairman of this Special Select Committee, and I now invite the other members of the committee to introduce themselves, starting on my right.
Dr. Ahmadi Singh, member.
Gerald Ramdeen, member.
Alison West, member. Good afternoon, ladies and gentlemen.
Good afternoon, Garvin Simonet, member.
Good afternoon. Jennifer Witties Primus, a member, and it's very lovely to see so many familiar faces. Welcome.
Good afternoon, Sophia Choate, member.
Good afternoon, Anita Haynes, member.
Good afternoon, everyone. Paul Richards, member.
Thank you very much. The committee is also supported by the Honorable Attorney General Faris Al-Rawi, who is the mover of the bill, and the staff from the Attorney General's office and the CPC's office. We also have a secretariat that is provided by the Parliament. We have before us this afternoon representatives from 6 organizations who have accepted our invitation to appear before the committee and make written submissions in advance of today's meeting. 4 of those organizations have made a single submission, and those organizations are the Coalition Against Domestic Violence, the Caribbean Center for Human Rights, Women's Institute for Alternative Development, WINAD, and Womantra. We have separate submissions in writing from Vision on Mission and the Child Welfare League of Trinidad and Tobago. I want to now invite the representatives from Vision on Mission, followed by the Child Welfare League of Trinidad and Tobago, followed by Roberta Clark on behalf of the other 4 entities, to introduce yourselves. Thank you.
Good afternoon, Mr. Chairman. I'm Antonia Popplewell, Trustee, Board of Directors, Vision and Mission. And with me is Mr. Gordon Husbands, Vision and Mission Program Director. And we want to thank you for having invited us to this session.
Thank you.
I am Dawn George, President of the Child Welfare League of Trinidad and Tobago Incorporated. And with me is Ms. Ross. She's a coordinator of the Child Welfare League of Trinidad and Tobago. And we are happy to be here.
Thank you.
Good afternoon, Mr. Chair, members of the Select Committee. My name is Roberta Clark, and I represent the Coalition Against Domestic Violence. And with me are representatives of 4 NGOs, and I would like to invite them, with your indulgence, Mr. Chair, to introduce themselves.
Thank you very much. No problem.
Diana Mahabia Wyatt, President of the Caribbean Center for Human Rights.
Elizabeth Solomon. I'm actually the Executive Director of the Caribbean Center for Human Rights.
Fulari Mututa, Executive Director, Women's Institute for Alternative Development, WINAD.
Regan Rowans, member of WINAD, Women's Institute for Alternative Development.
Stephanie Leach, founder and co-director of Womantra.
Elise Marslin, director of Womantra.
Thank you very much. I now want to invite Member Ramdeen to open this public hearing with some questions to the entities that are before us.
Thank Thank you, Mr. Chair. I want to first thank everyone for making themselves available to contribute to the Special Select Committee and for attending this afternoon to help us to try and better the piece of legislation that is before us. The first set of questions that I have, I would like to direct them to Ms. Clark and to more kind of get your views on certain aspects of the legislation. Ms. Clark, this legislation, by virtue of Schedule 1, if you have that before you, do you have a copy of the consolidated version? Schedule 1. There are certain sections of the Trafficking in Persons Act, Chapter 1210, that are regarded as registrable offences. And when you look at those sections, sections 16, 17, 18, and 19 of the Trafficking in Persons Act, the offences that are created by those particular sections have absolutely no sexual offending element in those offences. And I am happy to provide you with a copy of that legislation if you don't have it before you. And I would have liked to get to have, if you could have shared your view on having those sections as sections which a person who is convicted under those sections will be subject to being placed on a a national sex offenders registry, where there is absolutely no sexual offending as an element of those offences. I wanted to get your view on that. I also wanted to get your views. Can I go through them individually and then you can respond? I also wanted to get your views on the fact that all of the offences that are prescribed by the Sexual Offences Act, all of those offences, someone who is convicted of them will be liable or will have their name placed on a national sex offenders registry. And there are certain of those offences that respectfully I can point them out to you so that you can consider them individually in answering. Section 55, which creates an offence about confidentiality. It has absolutely no sexual offending element in that offence, but someone who is convicted of that offence, as presently prescribed in the legislation, is someone who will be liable to have their name on a sex offenders register. The same thing applies to Section 32. The same thing applies to Section 31D. Section 31. I'm sorry to me just piling it on, but I would really like to get the assistance from you. Section 22 and Section 23. The concern that I have, Ms. Clark, and you're someone with a vast more experience than myself, is that these offences are offences for which there is absolutely no sexual offending element. And the way the legislation is presently constructed, all offences under the Sexual Offences Act make someone who is convicted of any of the offences liable to being placed on the National Sex Offenders Registry. And then I would like to focus in on and to really get your view on the way in which Section 35 in particular is structured. And I would really like to direct the ambit of Section 35 to both yourself and to Ms. Mahabir Wyatt. Why I would like to get your view on it is because I have a very grave concern that under Section 35 of the Act, that is as is presently prescribed, you have it there, Ms. Clark? Section 35. That is the side note is mandatory medical examination of person charged with a registrable offence. The way this section is constituted is that a person who is charged, who is supposed to be guaranteed the presumption of innocence because he's only charged, is to be subject to a mandatory court order to be medically examined. If that person resists being medically examined, you can use reasonable force to carry out this medical examination while this person is guaranteed the presumption of innocence. You then carry out the medical examination of this person and you get their medical records as to whether they have a sexually transmitted disease, sexually transmitted infection, sorry, to use the words of the legislation. This person who is guaranteed and is not convicted, you then take their personal medical records and you share it with the virtual complainant or a representative of the virtual complainant if they are deceased, or a guardian if they are a child. And all of this is taking place while this person is presumed to be innocent. And if this person is then goes through the process of a trial and is found to be innocent, they have been medically examined, personal information has been shared with a third party, and reasonable force can be used to extract this medical examination from them. And I would have liked to get your views, your view and the view of Ms. Marbia Wyatt as to whether you consider that to be, 1, constitutional, and 2, proportionate, and 3, whether that accords with legislation that a reasonably democratic society will approve has been in accordance with the rule of law. I'm sorry to have dumped all of that on you in one go, but I would really appreciate your views having regard to the experience that both you and Mr. Anna Marbia Wyatt have in this particular field. Thank you.
Thank you very much. Mr. Chair, some guidance, please. We have also come with a prepared statement, a rather short one, which we'd also like to give, as well as answering the specific questions from Senator Ramdeen.
You can proceed.
Yes, thank you very much. Okay, so we, the ad hoc coalition of non-governmental organizations which are represented here, want to start off by saying we really very much welcome the work of the Senate Select Committee and this opportunity to be consulted. Through these hearings, for which we also advocated in our 2 submissions earlier this year, we can deepen, we think, our collective understanding of the dimensions of sexual violence and the possibilities within the legislative process to improve the administration of justice and to prevent sexual violence. We note that other jurisdictions have implemented sexual offenders registries, some non-public and some public, and there have been evaluations of these approaches to which we should have recourse and we can all glean learning. And while these will be helpful, we are also advocating that our legal and policy options have to be informed by our socio-economic and cultural particularities of this country, which is a small country, and of course also by the specifics of our gender relations and unequal gender relations. So we think that the legislation should be based on evidence and that the means and the ends should be well aligned. It should be rational, in other words. We should need a rational approach. And we appreciate the focus on the prevention of recidivism and understand the theory behind the proposed establishment of a public sexual offenders register. It is intended, we understand, to deter sexual offenders from reoffending. It is intended to enhance law enforcement investigations and indeed to increase public perceptions of safety and of the reality of safety. Notifying people of the location of a known sex offender is expected to encourage community members to take precautionary measures. Police are able to more closely monitor convicted offenders to deter reoffending. Community members are empowered to provide additional surveillance of sex offenders to monitor suspicious behavior. Finally, public shaming is expected to deter from reoffending, while the perceived risk of public shaming may also deter first-time offenders. So there's a reoffending deterrence as well as a primary offenders deterrence. However, we've been looking at some of the evaluations from other countries that are available to us. And these evaluations, which are not in any way definitive, But they seem to indicate that the theory notwithstanding, that while public sex offenders registries may have a small deterrent effect on first-time offenders, they do not reduce recidivism. And I believe members of the committee, you would have seen those studies as well, but we will share them if you would like them. Further, despite having strong public support, these registries appear to have little effect on levels of fear in the community. And this is especially the case where there are no therapeutic interventions during the period of incarceration of the sex offenders. And one reason offered as to why sex offender registries may be ineffective at reducing sexual offending or indeed reoffending is that they focus on averting the relatively infrequent event of persons being attacked by strangers, whereas the research, and this is global research, and it's research that applies to Trinidad and Tobago, has consistently shown that the majority of sexual violence here is perpetrated by persons known to the victims, either by family members or acquaintances. And unfortunately, the majority of those who are violated do not report to police. And even where sexual violence is reported, there's attrition all the way through the justice system. So let us be clear that the Sex Offenders Register, without other reforms or approaches, will capture a minuscule proportion of sex offenders. And as the written submission points out, which you have members of the Select Committee, and points out from the IDB study which was done in this country in 2016 and 2017, 16% of the women in that survey who reported experiencing violence, only 16% I should say, reported to the police. And a case was opened in just over 50% of that 16%. So further, only 17% of the cases that were opened led to conviction. So you have terrible attrition all the way from reporting to conviction. And so we want to urge a more comprehensive approach be taken to the amendments to the Sexual Offences Act. Such a comprehensive approach should address the factors that deter reporting and undermine the efficacy of the administration of justice, including, unfortunately, delay. From the annual report of the judiciary for 2017, 2018, we understand that only 34 sex offender cases were disposed of. We don't know what the meaning of disposed of, but were determined one way or the other. So only 34 cases were disposed of. And of these, a full 57%, more than half of these 34 cases that were in the system for over 4 years. And 32% of these cases were in the system for 6 years and more. So you have this dreadful delay, and it's in this narrowing pipeline, so few cases being determined and disposed of by the justice system. This, we think, is the problem. Underreporting is a problem. The administration of justice is the problem. So this limited focus on a register does not address this problem of impunity, because if you have underreporting and under prosecution, and then you have really impunity for sexual offenses. A register without a focus, moreover, on therapeutic or psychoeducational, I should say, and/or psychoeducational interventions during and after incarceration will impede reintegration, whether within the workplace or the community, for the offender, and seems more likely to increase the risk of further dysfunctional behaviors. And not only sex offenders, sexual offenses, but other kinds of dysfunctional behaviors. And again, there is some research on that from other jurisdictions, that the registers without therapy or some other kind of intervention increases anger, rage, interrupts integration, and leads to dysfunctionality. So we want to say that the basic principle, one of the basic principles of this legislation should be to do no harm. It's a good principle to live by in any event. There should be no collateral damage, especially if such damage is reasonably foreseeable, which we think it is, and we'll be speaking to that later on. The approach should be rational, again, in the sense of an alignment of means and ends should come together. So over the course of this hearing, we will indicate that we absolutely support the idea of a sexual offenders registry, but with more limited scope and complemented by a focus on rehabilitation. We hope to engage the committee on several questions, including the one that you have raised, Senator Ramdeen, which is whether or not we have over-inclusivity or overreach of those persons who will be caught by this legislation. We want to talk about the objectives of the legislation, Should it be preventative, and in what ways? We want to talk about the overreach of those may be exposed to mandatory testing, I think implicit in what you have raised as well, Senator. We want to talk about the need for judicial consideration of entry onto the register rather than a purely legislative or administrative approach, which we think this approach brings separation of powers into issue, and we want to talk about that. We want to talk more about the rehabilitation and make some suggestions on that. And then, of course, the big question, the need to limit access, public access to the register. And finally, we want to talk about the dangers of stigmatization, the collateral damage for members of families, and indeed stigmatization of communities. So that's our opening statement.
Okay. Thank you very much.
Yeah.
Before we come back to the questions raised by Senator Ramdeen, we have a written submission from the Child Welfare League, and I want to invite the Child Welfare League to talk about the written submission and to provide us with your comments on the bill.
Mr. Chairman, as we said in our written submission, we find the bill was thorough. But once the bill, we want that once the bill is implemented, is passed, that it is implemented immediately. It is not put on a shelf and shelved there for a while, because bringing it in immediately will help the court to be able to make decisions on how they treat these sex offenders. And these sex offenders will then realize that they are going to be put on a register, because that it goes to the court. And when they are incarcerated, that they have rehabilitation, proper rehabilitation, so that they will not come out of prison and do the same thing again. We also stated that it will prevent people who think, well, you know, I could try this. They are not offenders. First, to make a first-time offense, they will also be stopped from doing it once they realize that their names is going to be put on a registry. You adding anything? It will also give parents some sort of comfort that with the registry and knowing who these sex offenders are, because they're on the registry and you can find it hanging up in the police station anytime you want, because we are hoping that the names remain on the registry forever. It must not be taken off. Yes, it could be taken off the website, but it must remain on the registry, so that it will give them comfort to know that when these people come out of prison, they are not going to be doing that again. We are hoping that they would not do that again.
Thank you very much, Mrs. George. We also have a written submission, as I indicated earlier, from Vision on Mission. And I now invite Vision on Mission to give us your opening remarks on your position in relation to the bill, and then to quickly highlight any matter you want to highlight before we get into the depth of your submission.
Thank you, Mr. Chair. Vision and Mission in general is in support of the bill. We see it as a means of trying to put some sort of regulatory measures in place to treat with sex offenders. There are benefits, and these have been mentioned by the other speakers, particularly in the area of reducing, we believe, the rate of recidivism, also increasing public safety, and serving as a deterrent, particularly for first-time offenders and we think for reoffenders. We feel, however, that there are areas that the bill is short on, and as with the other NGOs, it is particularly in the area of treatment, therapy, rehabilitation. Because we have the view that reporting alone would not treat with the issues affecting offenders. You need to put some measures in place that will address the treatment, therapy, and rehab while they are on the registry, but while they're in the reporting term and even after. We believe strongly that that area must be looked at. Some of the areas that we would have highlighted in the submission, and I believe probably Ms. Clark may have been alluding to that, we feel there's a role for the court, apart from the Commissioner of Police, in terms of some checks and balances for the register. We also suggested in our comments that there should be a separate and confidential private national sex offender registry for child perpetrators, because those are child to child, and they probably don't come to the fore, but they do occur. And we have suggested that in our submission. We also spoke to the issue of the community being informed, the victim being informed, and the victim's family being informed, not just the Commissioner of Police and Prisons, but that these people need to be informed that the sex offender is being released and is being returned back into the community. So those are some of the areas that we probably will just highlight now, and we can go into further details as we proceed.
Thank you very much, Mrs. Popplewell. I want to invite Ms. Roberta Clark to continue your
sorry,
submission.
Mr. Chairman. Sorry to interrupt. Womantra also has a written statement. I don't know if you would want us to...
So I just wanted to say thank you, first of all, for the opportunity to provide feedback to this much-needed legislation. As gender justice advocates, we are agonizingly aware of the extent to which the epidemic of sexual offending requires immediate, deliberate, and consistent state intervention. The move towards amending the existing legislation and effectively implementing a national sex offender registry is therefore commendable and imperative. We are provided now with an opportunity to enshrine into law an ideological praxis of compassion that centers victims over actions or perpetrators, recognizing that the two identities are rarely mutually exclusive. Ensuring that the next steps achieve the objective of creating a culture of justice requires sensitivity and foresight that ought not be guided solely by a drive to increase punitive measures, but by a motivation to reduce and even eradicate the incidence of offending, rehabilitate offenders, and successfully support victims. As it stands, the existing legislation and proposed amendments place a heavy emphasis on punishing what it deems to be criminal acts, and none on preventing the acts themselves or the rehabilitation of the persons involved, which has been raised several times already in the room. Considering that the risk of offending and some of the most significant impacts of sexual offenses is situated squarely in the psychological domain, any modern legislation attempting to address the phenomenon of sexual offending should infuse a prescient awareness of this fact in its design. To do so, we must carefully consider the following questions. What strategies will be the most effective at curtailing incidents? Who are the persons that pose the greatest risk of offending and reoffending? How are victims' needs being meaningfully considered in the design and implementation? In answering these questions, some themes must be cogently explored. The nature of registrable offenses. Of note, the proposed amendment seeks to include all offenses under the Sexual Act and Part 4 to 6 and 8 of the Children Act as registrable offenses. Put in context, this would see the undue penalization of vulnerable populations and do little to address the system of inequality that promotes particular offenses or that has erroneously criminalized others. More precisely, this act would see sex workers and their dependents, as well as persons engaging in same-sex sexual activities, being treated as registered sex offenders. Furthermore, the question of how victims turned perpetrators will fare in a draconian system that fails to acknowledge their victimhood takes paramount relevance. In considering these worrisome truths, the question emerges, who are we really trying to protect our citizens from? Taking heed of the post-colonial patriarchal hegemony that has taken precedence in our legislative agenda, our focus should be to dismantle the mounted hardships of vulnerable populations. To do this, we must understand which offenses create the greatest threat to the safety and dignity of our citizens, and as opposed to policing those that only threaten our sense of moral superiority. These would include crimes against a child, crimes against a person other than a child, and trafficking offenses. At the root of each of these categories of crime is the idea that a victim has been made of someone. It is that someone who must remain plastered at the forefront of our consciousness, which segues into the next theme, determining the risk of offending. In determining who is added to the list, the level of risk that is posed to society must also be analyzed. If the goal of the registry is to act as a deterrent, then we must consciously decide what it is we are hoping to deter. By creating a dedicated system that effectively assesses the risk of an offender poses to society, we may be able to better gauge not just the need for their name to be placed on a list, but also the specific interventions that might help bolster the efficacy of that list. Prior to even registering offenders, actions should be taken to ensure that their threat level is reduced. Taking a victim-centered approach also necessarily informs the model to be considered. Intervention strategies such as victim-offender mediation have offered an empowering alternative to the pecuniary compensation strategy that is currently employed. This method moves away from the established status quo of retributive justice, while affording victims an opportunity to unpack deep-seated trauma under the supervision of professionals and create space for offenders to engage in essential self-reflection and self-work. Integrating psychosocial interventions such as regular individual and group psychotherapy, gender-sensitive education, and skills training would augment the judicial process with a view to curbing reoffending. In doing so, the register would serve as a powerful monitoring tool that performs a dual function of recording or tracking offenders, as well as evaluating their progress. And this leads to the final theme, supporting victims and ending violence. At the core of this issue, a need to understand what is needed to create a healing and supportive environment for victims, and a culture that no longer breeds offenders extends across every concern that might be raised. How do we do both? Understanding that perpetrators of sexual violence are nurtured by our ever-prevalent culture of domination and violence is key to moving forward. Though conceivably beyond the remit of this one piece of legislation, the creation of new laws can act as a precipitant of cultural change. Adding schedules that outline the responsibility of state actors and others in authority to address the occurrence of sexual offending through the education and service provision for both offenders and victims can have a profound impact on actually ending the cycle of violence. The responsibility of the state at this important juncture is not just to create laws, but to foster societal change. This change can hardly be brought through just punitive legislation, but through an intersectional, multidimensional approach to responding to and addressing the problem of sexual offending with an objective of spearheading its cessation. Thank you.
Thank you very much. Is there any other entity before us who has a prepared statement? No? Thank you very much. So I would revert now to Ms. Clark.
Thank you, Mr. Chair. And there may be others amongst us who will also address your question, Senator Ramdeen. But the first question relates to the scope of those offences that would be captured under the term registrable offences. And we have submitted on that, and we also think that there's a bit of an overreach there. Under the proposed amendments, all offences created under the Sexual Offences Act will be registrable as sexual offences under the register, as well as specific provisions in the Children's Act, and as you've pointed out, the Trafficking Against Persons Act. In relation to the sexual offences, we think that the overreach is the most dramatic, because apart from the offences that you have captured, it will also capture Section 31, I believe it is 31, which is the mandatory reporting obligations of certain persons in relation to offences against minors. And so that means those are teachers, guardians, nurses, medical professionals, psychologists, who may fail to report as they should. And whilst that is, yes, an offence, is that an offence that we want reasonably to catch within this legislation? And we think definitely it is not. It doesn't belong there. We hope that, we think it might be an oversight in the drafting, and we've asked for a specification of the offences in the schedule, all of them, because when we do that, it will be very clear what we're trying to capture, what is the common element there. What you're trying to capture is danger of offending, sexually offending, and not all of the categories in the Act. And again, also, our colleagues from Womandra have spoken also about sex work, prostitution. That's also caught here in this legislation, as well as same-sex intimacy, although that itself, I suppose, is before the courts in consideration now. So yes, we do think that the scope of what is registrable should be limited, and we make some suggestions on that. We are recommending that the registrable offences should include any of sexual offence involving children, dependents, categories of vulnerable populations, like persons living with disabilities, for example, the elderly. And this would include not just physical violations, but other forms of violations, including the use and dissemination of child pornography, dissemination of pornographic materials to children. So a bit larger than just physical violations, but all offenses related to involving children. So that's one category we think should be captured in the registry. All sexual offenses committed by a sex offender against someone other than a child, so all other categories of persons, and then we think trafficking offenses in the context of offenses that cause physical harm and are related to sexual conduct. I don't have the Trafficking Act before me, so I'm not quite sure which are the sections to which you're referring, but I think in principle we agree with the implicit critiquing embedded in your question, and we think that the scope of what is registrable should be limited, or more limited than it is right now.
Mr. Chairman, may I ask a question, please?
Sure.
First of all, welcome everyone, and thank you for your very fulsome contributions before and at this table. Certainly the government is extremely pleased to have your voices part of this. Ms. Clark, I know that you did not come to answer questions yourselves broader than scope, but Senator Ramdeen's questions are very germane and also quite pointed. The government has already taken a position to schedule out offences, but I want to ask, for the benefit of the committee's fulminations, what your coalition's view is in relation to inchoate offences. And by that, I'm specifically looking at the other side of what you've just halfway discounted, the trafficking in persons aspects, and also the Children's Act aspects, because we're concerned to find that balance between things which are preparatory to or associated with sexual predator behavior, which I think no one can say is far away from trafficking in persons, as we've had a live example of 19 young babies being prostituted out, raped, drugged, etc. I'd say allegedly for the purposes of the law at this point here, but the evidence is in the public domain. So what's your view on the inchoate, preparatory, related aspects? And then secondly, insofar as your opening statement pointed to two essential issues. One, the administration of justice, effectively, and two, underreporting. Doesn't that fly, or rather, would you help me to assist understanding your submission insofar as mandatory reporters not being put onto a register can very well fuel the very thing that you're complaining about? So if the Children's Act criminalizes people who don't report, if we've had the Sexual Offences Act putting it as a crime for failure to report, and as a result of the non-functionality of the laws or the willingness of society's views towards reporting, you yourself, Trinidad and Tobago's diligent entities such as yourselves have come forward and said, underreporting is a problem. Isn't this thinking outside the box to say, if you don't report, you may find yourselves guilty of an offense and being made known public for your quote-unquote negligence? Because I want you to put it alongside the fact that we have reported as a government for the first time in the history of this country the statistics of pregnancies to children, children having children. I, as Attorney General, have put out the statistics of 12-year-old girls and 11-year-old girls having babies. And I want you to talk to me about and talk to the country about whether it is really overreaching to say to people who ought to report but who are not reporting that there's a consequence to be found by going on to a public register. Because when we focus too narrowly on just the sexual act, are we really getting to one of the two main issues that you've pointed out, which is underreporting? So could I ask for your other perspective now as I'm asking the antagonistic question? I don't mean antagonistically in that sense, but the polar position to what Senator Ramdeen asked.
I don't know if Diana, if you wish to take some of those questions, and I will come back to the last point, Attorney General.
Okay, thank you very much. And thank you, Senator Ramdeen, for giving us an opportunity to speak on this issue, because it is one which is very troubling. Normally, to be put on something as serious as a sexual offenses register, and there are two questions here. One is the right to know who is on that register. And I think that we have in the past made comments about there should be different steps in terms of seriousness. If a school teacher, and I'm talking from an actual experience that happened in Tobago, where a school teacher was told by a child that she had been sexually molested by someone in her family. Now, it was just the teacher that was told. The teacher, unfortunately, when she went home that night for dinner, was so upset about it, she mentioned it at the table. And it was her brother who reported to the reported offender that the teacher had told them about this. And, well, you know what Tobago is like. Stories carry very quickly. And the offender killed the teacher. He murdered the teacher because this report had been made. Now, he claimed he was on his way to report it for himself when he heard about this and decided to take revenge. I think in response to your specific questions about the trafficking, for example, where there is, this act is there for a reason, and it is a Sexual Offenders Act. If it is the mother who does not report, and I've known many cases of this, where the mother is not going to report to the police that her daughter has been raped by her stepfather or her father or a male relative. She doesn't do it because she knows that there will be repercussions within the family, and she herself will run the risk of being killed. I think that this comes under the rubric of extending the register, or extending the term sexual offenders too broadly. And we have to take into account the very deep cultural roots of family relationships in this country. I think that if somebody has not actually been convicted, but they have merely been suspected, and what the Act says, which I have in front of me, says that if someone is charged with a registrable offense, now they have not been convicted, there's been no proof that they have actually done it, to actually put, number one, put their name on a register for everybody.
Sorry, Senator. I'm sorry, I'm still calling you Senator. You're not put onto the register on charge. The STI investigation for the purposes of compensation allow for medical reports to happen so you'll know if you contracted a sexually infectious disease or not. You're only put onto the register after a court has convicted you or through the charge process having gone to court. So you don't come onto the register until you are convicted.
Right, okay, which is right and proper, thank you. But it does say in Section 35, subsection 1, where a person is charged with a registrable offense, which would include not reporting. As the mother or the grandmother of the child, I did not report it because I thought it would be too damaging psychologically and emotionally to the child. The court shall make an order requiring that the person be medically examined. Now, that whether the person agrees to it or doesn't agree to it, according to subsection 2, they can be forcibly medically examined. That makes me a little bit uncomfortable, without their consent. And the question that Senator Ramdeen asked about the constitutionality of that is one which I think needs to be looked at, whether constitutionally you can forcibly medically examine someone, which includes penetration, etc., without their consent is something which I feel very worried about. And the other one is that the question of trafficking, which when I looked through the Trafficking in Persons Act, while I accept your point entirely about the inchoate offenses, that it may be implied, although not proven, that every time somebody is trafficked, that they may be sexually abused. From what I gather in Trinidad, there are a number of boys and young men who are being trafficked. They're trafficking of persons, not necessarily for sexual reasons, but they are trafficked for the reasons of construction work, for example, or various other activities which have nothing to do with sexual activity. Again, I am a little bit uncomfortable about forcibly ensuring that this person has to be medically examined even without their consent. While subsection 5 says that the subject to subsection 3, which is if they're suffering from a sexually transmitted infection, that you have to let the person examined being known. Well, I think that's fair. The virtual complainant, if, and I am assuming that this would only be, the complainant would only be told if the person being examined is found to be suffering from a sexually transmitted infection, which means that it may have been transmitted, which I believe is the purpose of that particular subsection. Then the virtual complainant may be medically examined to determine whether they are suffering from a sexually transmitted disease. If I do what I am supposed to do, and I am complaining that my granddaughter has been sexually abused by a virtual, a virtual accused, why is it that as a complainant I can be examined?
Sorry, I'm sorry to interrupt. Forgive me, but it's necessary because we're being recorded and reported that I put some clarity into this as the drafter of the bill.
That's why we're asking.
Subsection 6 of Clause 10, which is the amendment to 35, says, where an examination conducted in accordance with subsection 4 reveals that the virtual complainant, that's the victim, is found to be suffering from a sexually transmitted infection, which the virtual complainant may reasonably have contracted from the person examined. The law must be read as a whole. Subsection 6 means that it's not just because you are in an inchoate offense, you were the pimp, you were the person that procured something, you can't be examined. There must be the nexus of sexual relationship. So Section 35 would never be read to be that anybody associated with this would be examined. It's if the person was sexually assaulted, that's where it happens. So I need to put the law into the context of what it means. Secondly, it's important to note that the constitutionality argument has been decided ages ago, particularly with the DNA Act. You can forcibly take somebody's DNA if they're deported, if they're charged, etc. That law has gone to the European Commission on Human Rights in the case of MARPA. It's been dealt with by umpteen courts in Trinidad and Tobago in other situations. So the constitutionality aspect that I got from Roberta was the question of, forgive me for Ms. Clark, was the separation of powers argument, Section 90 of the Constitution. I looked at it in that context and not the issue of consent or no consent on that end. But I asked a specific question which was passed over. and over for answer. And the question I'm asking is, if the IDB 2017 report says 16% of people actually report, and only 50% of that 16% find their way into the police hands, and I'm saying, and I'm asking in that saying, if the underreporting is an issue, because if I were to distill the submission, number one, criminal justice system, and number two, underreporting are the two standout points. The criminal justice system, you know, is under heavy renovation, and I don't need to go into that now, but you all know the work on the children and family side, etc., and divisions of court, proceedings rules, etc. There's massive work. The underreporting. Children's Act, Sexual Offences Act, medical legislation, etc., the teaching regulations and rules and laws, all say it's a crime not to report certain things. 16% is the figure right now, and the entities have said underreporting is an issue. So I'm asking the question, which I'd like to hear your views on, in the context of underreporting being a huge mischief, and this law saying that if you don't report, you may find yourself, if a court convicts you of not reporting, being on a sex offenders register because you should have said that a child was being sexually molested. You should have said that a child presented at 12 years old, pregnant, and had birth in circumstances where that is an offense to the laws of Trinidad and Tobago. I'm asking you for your point of view on whether you really think that that's an overreach to the Sex Offenders Act in putting a register.
Thank you, Mr. Attorney General. Sure.
Thank you, Mr. Attorney, and I do understand your point. There are a couple of clarifications I'd like to make. I think that testing for DNA is quite different from a medical examination to determine whether or not you have contracted a sexually transmitted infection in terms of the intimacy and the reactions to that. That's number
Except
one.
that there are intimate and non-intimate DNA tests as well.
Yes, but you know, a piece of hair is often used.
It includes vaginal swabs, semen samples, and blood.
Which can be, yes. But I submit that there is a difference in the intimacy of those two things. Secondly, I think that in relation to the question about prevention, the Sexual Offences Register is not effective in preventing sexual abuse or sexual offenses. It is punitive, yes, but in terms of the lack of reporting, the differences is that there are reasons for lack of reporting which may not have been taken into consideration from the point of view of family relationships and the safety of people within the family who may have been the only ones who knew or who were told by the child about the particular sexual offense. I think that perhaps one of the ways in which this can be dealt with is to have different degrees of reporting. In other words, that there should be a need to know before somebody can apply to see what is on the register. In other words, what is your need to know? And I think that that one is important, and I think that there should be different degrees of need to know. Otherwise, I think that some of the sections of this bill, in particular, I'm looking at Section 35, are disproportionate and should perhaps be looked at again in relation to the question of non-reporting, which I think is one of the particular ones which is disproportionate. And I wanted to ask one question, which I don't know whether Senator Ramdeen can comment on, which he didn't, is the subsection 6, subsection B, about somebody who has been convicted of an offense particularly if it's a non-reporting offense, is being charged that have to pay compensation to the virtual complainant. One of my problems with this is that under that section 6, subsection A, the application can be made by the virtual complainant or, little 2, a representative of the virtual complainant. And if we are looking at the need to be medically examined, if you are a virtual complainant, which I am not clear under subsection 3, whether the virtual complainant there would also legally cover little 2, which is a representative of the virtual complainant.
Okay, thank you, Mrs. Mahabir. While before I give both the AG and Senator Ramdeen the opportunity to respond, there was one question that the AG asked that I don't believe you answered, Roberta Clark. So I'd give the AG an opportunity to go back to that. Then I would invite Senator Choate to make her submission, and then we'd come back to the responses from the AG and Member Ramdeen on that particular issue.
Thank you, Mr. Chairman. I was just about to hand over to Mrs. Clark.
I think you got my question. I asked it twice. The underreporting issue and in the context that I've put it.
Thank you. Mr. Chair, I do have a very specific response to the underreporting, but my colleagues also want to address the point of the inchoate offences and also underreporting. And there are about 3 persons who wish to respond to that inchoate offence. So guidance, please.
Yeah, okay, before we go on to the other submissions on that particular issue, I want to invite Member Choate to raise her issue. Thank you.
Thank you, and I must say that I welcome the views of the members of these groups, and it's wonderful to hear your voices speak out on issues such as these. We on the committee have already discussed amongst ourselves many of these issues, so it's good to have new views. Ms. Clark, you indicated that you had done some research on that there were reports which you had. Would you be willing to share that with us? And secondly, in any of those reports, was the issue of registration as an effective measure to prevent recidivism considered? And if it was considered, what was the outcome? Thank you.
Proceed.
Mr. Chair, I will respond on the non-reporting, and then my colleagues will respond on the questions of the inchoate offences, and then also on the effectiveness of the registries. So there is significant underreporting, but the underreporting at the first level is underreporting by victims themselves. And that survey, the prevalence survey done by IDB in Trinidad and Tobago in 2016-27 was a survey of women between 15 and 64, I think that was the age band. And of those women who experienced, and it was domestic violence and sexual offenses, but in particular domestic violence, only 16% reported. And for the most part, they reported to the police. Actually, few of them reported to health workers or social services, and many also spoke to their families. So that underreporting has 2 components: underreporting by victims themselves, and then underreporting by persons in positions of guardianship or with some sort of care relationship to minors. And so in both categories, there is significant underreporting. Now, I think you're referring to the underreporting in relation to persons who have care responsibilities for minors. And there's also, well, we assume that there's underreporting there because, in fact, there's so very few charges or prosecutions against persons in those situations or relationships of responsibility. So we think the first thing that has to be done, first of all, is to understand why are those duty bearers not reporting? Do we understand why? I think Ms. Mahabir Wyatt spoke some of those reasons, particularly for parents and guardians. They're embedded in a cultural structure, and also with fair economic dependencies. There are many reasons why they may not report. We have to understand that. Should our response to that non-reporting be a punitive one, and an extra punitive one, apart from a conviction, then you now go on a sexual offenders register. So I think it is an overreach, because I don't think we understand fully the dimensions that keep people from reporting family members.
May I ask you if you could expand, please? I want to separate out domestic violence, because we're not on domestic violence at any point in this bill.
Yeah.
Take that statistic off the table for a moment. We'll treat with that elsewhere. Sexual offenses. I'm talking about specifically the underreporting. The persons can be caught under the Sexual Offences Act, and that's what we're looking at, because we've scheduled trafficking in persons, sexual offenses. I'm talking about that instance where the underreporting is known to a third party who must know, and then a court has said you didn't have a reasonable excuse to not report, and a court has convicted you. So I'm not talking about domestic violence. I'm not talking about anything else. You still hold the view that it is an overreach to go behind those persons who really ought to say something.
So child sexual abuse is, for the most part in this country, domestic violence. It's covered under domestic violence. A lot of the child sexual abuse
I want to look at it in the Sexual Offences Act. This is not talking about the Domestic Violence Act. The Sexual Offences Act itself. Just for clarity, so I want to catch it so that when we're sitting in the committee afterwards that I've done it right. So forgive me for interjecting.
Right, but I think that relationship is important for understanding what you have to do about it, because a lot of child sexual abuses happen in the context of the family. And parents and guardians are not reporting as they should, or not reporting to the police for many reasons. And I think we have to understand why parents and guardians are not reporting. Maybe it's sheer recklessness and negligence, and then there may be other kinds of reasons why they don't. Shame, stigma, there's quite a bit of work on that. So do we want to punish those parents who are in those situations of dependency or fear, or the social, cultural dynamics? We don't understand fully why they don't report. So I think, I think it is an overreach. It's over punitive to not only charge and convict and then put them on a register. Now, which please don't get me wrong, Attorney General, we do have to do something to impel guardians and parents to act in the interest of their children. But do we have to put them on a sexual offenders registry, I think is the question here. So we would say that we would recommend against that. It's extremely punitive, and it doesn't necessarily help. And what it may do, in fact, ironically, and we have a psychologist here with us today, it may actually suppress. It may suppress rather than encourage reporting. So maybe I can just pass on to my colleague, Ms. Robertson.
Thank you very much. I think that particular point has been made, and I think we understand the submission. It was very helpful, and I want to invite the other entities who may have a submission to make on something that has been raised so far to make your submission.
Mr. Chairman, if I may, I speak particularly from a corrections perspective. I think there need to be a proper definition in terms of when we looking at sexual arousal disorders, because from a correctional perspective, this is how we look at it in terms of what are some of those sexual arousal disorders. And top of the line is pedophilia, right? There's a series of paraphilias, right? Meaning there may be exhibitionists, there's the fetishism, right? We know the pedophiles are very, very, very high profile. There's the machismo, there's the sexual sadism and the like. Now, these kind of offenders, I want to submit, must be placed on a sex offenders register. I agree that there must be some kind of rehabilitation while they're incarcerated, right? Even when they are remanded as well. And while I'll get back to this, I think I also raised in the submission that the Commissioner of Prisons must have some kind of responsibility, right, to inform victims, right? Not only the police must have that information from the registrar, I think the Commissioner of Prisons must also have that register as well, and the people who are supposed to be there. But more importantly, we're talking about whether the rehabilitation is effective to answer Ms. Truth in terms of the level of reoffending among this particular group. The jury is out on that. In some jurisdictions, they have used what they call desensitization, cognitive behavioral interventions, aversion using shock, and of course, the ethical lithium castration. They have found that people who have gone through all those series in terms of the cognitive behavioral approaches, the aversion through shock, but they get the best results when they administer the castration. It's really a anti-androgen drug, right, which really suppresses, right, that urge, that arousal, because I started my presentation by looking at the sexual arousal disorders, right, and we have to take it from that perspective. I know the learned senator, Dr. Dialsing, had been under a lot of pressure, and I want to commend him, right, for making that suggestion, particularly from a corrections perspective. We are looking at offender management. We are looking in terms of public safety. We're looking in terms of even putting bracelets on those persons when they come out. Those who come out on bail, they need to be placed under bracelets. Once they have been identified using actuarial instruments to measure the risk, right, in terms of high risk, low risk, or medium risk. So I'm suggesting, even within the registry, there needs to be a tier system. Because you may have a voyeur, someone who gets his kicks from looking at persons, right? Yes, he's suffering from a arousal disorder, but that he doesn't pose this kind of risk that a pedophile, right, would pose on unsuspecting victims. So I'm looking at it from the point of view of recidivism. It works, the castration. We don't have it because we don't have a parole system, but that's one of the important areas to look at, particularly with sex offenders, right? They must go through that particular assessment using the actuarial instrument, which is very reliable and is a valid instrument. But more than that, when they come within the community, they must be tracked. They must be prevented from going certain places, in parks, around schools, and the like. Those are the things that work. Again, in the modern times of people taking selfie, people taking, posting all the big guns, why not post these persons on the website as well?
Okay.
Right? This is just my point of view from a corrections perspective. And it works. And it can reduce recidivism, or I would say reoffending in the first instance.
Right, thank you, Mr. Husbands. I want to invite first Member Richards and then Member Choate to ask their questions, and then I will come back to you, Mr. Husbands, with a question that I want to ask.
Thank you, Chairman. Through you. Good afternoon again, everyone. And like Member Choate, I thank you for being here. It's very important to engage groups like yourselves and the other entities that we have already hosted and that we will host coming up, to have this kind of discussion because of the seriousness of the issue that we're discussing here and the intentions. I'm sure that the Honorable Attorney General and the government have identified in terms of the need for this amendment bill, and these kinds of discussions, to me, critical and indispensable in coming to some sort of, not absolute consensus, but some common ground on making better law in Trinidad and Tobago. There's quite a bit of conversation, and many of the points that you would have made, I know would have been raised by many of my colleagues in the Senate regarding the complex issues we are discussing here today, including the understanding, and even since our presentations and the formation of this Special Select Committee in the Senate, I've had the opportunity to do even more research, and there are literally over 200 papers on this contentious issue of public national sex offender registry, which started in 1997 after Megan's Law, as we all know. But 1997 to now is quite almost 22 years. It's quite a span. And one of three of the research articles that I encountered actually started classifying convicted sex offenders in the following categories, including overconforming, antisocial, morbid, pedophilic, which are the ones that in the commission of their offenses, sometimes murder, low cognitive ability, because that's also a consideration, crisis response offenders, who are sometimes the offenders who, by commission or omission, are in those family dynamic circumstances that may be caught in these kinds of legislation, and also biochemical imbalance and neuropathological offenders. So you see, sometimes we tend to think of these offenders with one brush and make law for all and enact policy for all, when they should really not be. It should not be approached that way. Mike, and I've realized that the groups have dichotomous views on whether this national public sex registry should be part of it or not. And my question is for both entities, including Mrs. Clark and Mrs. Allen Rose, and also Mrs. Diana Mahabir-Wyatt and Elizabeth Solomon. For those who are advocates of the National Public Sex Registry, have we considered the immediate response of those communities and families? Because most of the research articles points to the unintended consequence being primarily the offenders, the victims' families and communities, and the offenders' families and their communities, significantly so. And especially in a small jurisdiction like Trinidad and Tobago, what is the immediate response, for conversation's sake, if this were passed today and a public registry goes public tomorrow, the immediate response in the digital age of those communities? Because when Megan's Law was passed and national sex registries became active in the US and other areas, we weren't in the digital age where instant information was shared profusely through many forms, and there's a social impact to that immediate sharing. And also, how do you propose we manage the different categories of offenders? Even if we had a limited access to this kind of registry, when I can apply because I have a valid reason, and also share that through my social media, even if it was limited for me, it is just going to be national anyway down the road in the digital age. So I don't know if you want to respond to those in terms of us grappling with the issues that are before us and the consequences of the passage of these kinds of provisions in the law.
Before you do, I know that Ms. Robertson Tony is anxious to make a submission, and perhaps you can open with a response to Member Richards if you have anything to say, or on something that has been submitted previously.
Mr. Chairman, sorry to interrupt you, but since my question was going to be directed to Ms. Leslie Robertson Tony, perhaps I could ask it so she can deal with it as well.
Yes, sure, Member Truth.
Okay, what I wanted to find out is whether there are particular mental conditions which you find in sex offenders. And the reason I ask it is because I heard Mr. Husbands refer to sexual arousal disorders, which I'm not at all familiar with. So I just wanted to know whether there is such a thing, and also what would it include?
Thank you, Senator Choate. I would like to first address Attorney General Arwari's question, but I think in my answer I might somewhat get to what you have asked about. I think it is important to distinguish between types of reporters. So we've been talking a lot about the unintended consequences of registering, if convicted, family members for not reporting. But it seems that Attorney General has been asking about mandated reporters, nurses, doctors, teachers, and others who work for institutions that would be privy to the types of information that would...
If I could clarify.
Yes.
I intended exactly what you just said, which is the very narrow one, the convicted by court of law reporters. What I understood the risk from the coalition bodies was, what about mandatory reporters who may find themselves on a sex offenders register? But my qualification to that was a court convicted you.
Yes. As it stands, there are penalties for not reporting, but we know that many cases go unreported. And so the intent of this registry is to inform the community and protect victims and protect additional victims protect us from having additional victims. I would argue that there are a number of ways to ensure that people who are mandated reporters improve their behavior in terms of staying in accordance with existing laws. One of the things that we know is that there are a number of sexual assault victims who are victims of pedophiles. But the actual definition of a pedophile is someone who's aroused by a prepubescent child. And what we have is a large number of victims who have passed puberty. And that speaks to the fact that there are attitudes about what is appropriate sexual behavior from a minor and what level of blame exists in a victim. And so many times, yes, we have children who cannot report to anyone other than a family member, but we have a number of children, age 10, 11, 12, 13, who are seen in schools, who are seen at hospitals, who show up to maternity clinics, and it is known that the father of the baby or the offender is an adult, and no one reports. And there are a number of ways to ensure that there are consequences for individuals who are often public servants for not reporting these crimes, and for police officers and others for not investigating and ensuring that something happens for this category. And this is a very large group of our individuals. In terms of what are the mental disorders, I am cautious about speaking about that without looking at a scientific paper, but the reality is that we have a number of offenders or perpetrators who are not actually pedophiles because they do not engage in sexual assault of prepubescent children. They are assaulting and engaging in relationships with people who are teenagers. And what we end up having is a number of people who they have a gray area in terms of, was it really a crime? Did this child really encourage it? And if we could ensure that there were adequate training across the board and adequate consequences, a loss of licensure, a loss of employment, different types of punishment that are meaningful for individuals who are often public servants and privy to this type of information, it is likely, I believe, to create more attitudinal change. Because one of the purposes of a registry is not just to warn the public, but also to create an idea in community that this is something, that the offense is wrong, that the offense is stigmatized. And when people, the public, when even victims believe that institutions, that the government is punishing the victims in a way that is too harsh, what happens is we drive a lot of behavior underground. And so I think it is very important to think in a nuanced approach about how do we take what exists as is and ensure that there are consequences right now, but also changes in attitude for people who right now should be punished for their part in not ensuring that we do have more convictions.
Could I just ask the question, please? Thank you so much for the elucidation. What is the view, in simple response? Should persons who are convicted by a court of law in failing to have reported sexual offenses be put on a sex offenders registry? Question one. Two, should persons who, under the Trafficking in Persons Act, exploit and take benefit from, I'll be narrow now, sexual trafficking in person which results in sexual offenses, not the wider trafficking in persons. Should they be included? For instance, persons akin to persons who harbor or pimp people out in trafficking environments, should they be put on a sex offenders register?
Even for that, I think there should be a nuanced approach. Are we looking at offenders, if convicted, who are involved in the trafficking of victims of sexual offense crimes, or individuals who facilitate these offenses? Are we looking at people who are closely implemented and not likely to be rehabilitated? Because the point of the registry is also to protect people from further victimization. I think if the answer is yes, that they are likely to commit these crimes again, I think it needs a nuanced approach, is really what I'm saying. I don't think that there should be across-the-board registration of individuals who are aiding and abetting.
Okay, so by nuanced you mean perhaps judicial discretion or degrees? Because if I flip it, should the public be made known, should the public be aware and know specifically John Brown pimped out 15 girls who were trafficked, and he's a registered sex offender, and therefore John Brown should not really be hired in an early childcare center or be looking as a school teacher for a job? I'm putting it in layman's context now, because that's really what this bill is aimed at, in part. The public awareness of persons who have proclivities to do things which are actual abuse items in terms of sexual conduct, or who promote or exploit that activity.
Not every offender who promotes or exploits is incapable of rehabilitation. And so I think the answer would be both. There is a need for a nuanced approach. There's a need for possibly judicial involvement, because it gives an opportunity for a presentation of additional evidence. To give a hypothetical scenario, perhaps John Brown is 28 and has led a violent life of crime where he has been involved in aiding and abetting the trafficking of victims, and he spends 20 years in prison and is able to benefit from all of the therapeutic and educational interventions that are offered, and gets a second chance. He's entirely different from someone who is actually classified as a pedophile and who the data support is unlikely to be able to benefit from treatment. That's a very small category of individuals.
Does the existing clause in the bill with respect to Section 53 catch your concern? It says that a complainant, a person who's on the register, well, likely to go on the register, can apply to the court to not be on the register or have the record expunged. That's one. And then two, how does one know from your perspective when you have not been cured?
I'm sorry, your question was
so
how
in
does
the
one
nuanced
know
approach
when one has not
where
been cured?
You present further evidence, etc. So the bill does provide a clause which says the person who's on the register or will go onto the register can apply to a court to not go onto the register. So the bill allows for that application process. But I'm asking a question. When is one not rehabilitated or deemed to offend again? In other words then, isn't it that it is the act of reoffense that is conclusive of that? A person who is reformed is deemed to be not reformed when they reoffend, correct? So in this nuanced approach, are we asking to wait until there's a reoffense? I'm looking at degrees. Because I've seen it in other jurisdictions, I'm trying to understand what the proposal is.
So there are two categories. We're talking about people who aren't cured and people who are rehabilitated. And risk assessments would be an integral part of that. Clinical interviews, psychological assessments, probation and parole assessments. There would be a number of evidence-based ways to assess before someone reoffends what is the likelihood. And then we could even adopt an extremely safe procedure for determining whether this person goes on the list or the level of freedom this individual has. But there are ways to, along the way, continue to assess what is the likelihood that someone will reoffend. And there are really two categories. There's a category of people who, for whom we know that the data support that it is extremely difficult to treat them, and it is likely that without a shadow of a doubt they will reoffend. And then there are other individuals who, with adequate intervention and sufficient time, are likely to change their behavior. So it is important that adequate assessments are a part of that as well.
Very last question for me to you, because of this area, is in the data and in analysis of these issues, how many small island jurisdiction states drive your data interpretation?
Unfortunately, none. That's another thing that I think it's important to take into consideration. A lot of psychological research, a lot of what small island states are benefiting from is the work of the global north, of European nations and North America. And it is important that as this legislation and other legislation tied to sexual offenses goes through, that we commit to improving our own capacity to conduct research, to gather data, and to do the type of analyses so that we can adequately predict in our environment what will happen in these spaces.
Okay, thank you very much. In the remaining time, this is how we would proceed. I want to invite first Senator Ramdeen has a question to ask, and after that I want to invite Mr. Regan Rowans from WINAD. You have a submission to make, and then I want to ask Womansha, based on what you have heard so far, if there is anything you want to add to the discussion. Having done that, I would come back to Member Diyal Singh, who is very anxious to ask something and make a contribution. At the end of that, I would ask the two entities, the Child Welfare League having already made their submission, I would ask the two entities to direct your attention to your written submission and give you an opportunity to take us through that written submission and address any matter that you have not already addressed in what we've covered so far today. So I want to invite Senator Ramdeen, followed by Mr. Rowans, then Womansha, Member Diyal Singh, and then the two entities, the Vision and Mission and the Coalition. Thank you.
Thank you very much, Mr. Chair. Ms. Robinson, Tony, I totally accept your nuanced approach to the way in which you think these offences should be treated. That's first. But I passed the Trafficking in Persons Act to Ms. Clark, and I wanted to suggest whether this would satisfy in any way what you are saying. If you look at Section 23, I think it is, of that piece of legislation, I hope that that is the correct section, but there's a section there that deals with the fact that certain offences provide the court with the ability, a discretionary ability, to increase a sentence where there is some form of sexual offending in the offences that are caught by the Trafficking in Persons Act. And there's a section very close to Section 23 that allows the court to take into account where there is sexual offending in any of those sections that are caught, which is 16, 17, 18, and 19. It's 23. 21, right, 21. Right, so that I was wondering whether what you are suggesting in terms of the risk of reoffending and the different tests that can allow a court to satisfy itself as to whether this is an aggravating factor in the commission of one of these offences, whether we cannot strengthen the legislation by using that particular section to allow the court to carry out the things that you are suggesting, which is the risk of reoffending and the different tests that can allow the court at that stage, where there is evidence, there is actual evidence of sexual offending in one of these trafficking offences, that the court can then take that aspect of it and carry it further to determine, as a matter of discretion, whether the person ought to be put on a registry at all, and there could be some kind of treatment that can be provided for. It's just a suggestion, because that particular section is a section that I think ought to have been incorporated in the legislation, because that is the section that allows the Trafficking in Persons Act, the sexual offending, to be taken into consideration by the court. That is number one. The other thing I just wanted to put to rest, and perhaps might be of great comfort to Ms. Mahabir Wyatt, is the fact that I found it a little bit strange when it was said that this whole issue about taking these samples has been decided by the court and is all decided already. Well, I have before me here the decision of the Grand Chamber of the European Court of Human Rights in the case of MAPA. And in that particular case, the court found that the retention of fingerprints, cellular samples, and DNA profiles of persons suspected but not convicted of offences fails to strike a fair balance between the competing public and private interests, and that the state has overstepped any acceptable margin of appreciation, and that the retention constitutes a disproportionate interference with the applicant's right to respect for private life and cannot be regarded as necessary in a democratic society. And therefore, it is clear that the taking of these samples of someone who is not convicted under Section 35 of this piece of legislation, whether the DNA Act provides for that or not, it is unconstitutional, and even if it is passed with a special majority, it cannot be justifiable in a democratic society. And I think it is something that we have to look very carefully at, because that is what the courts have said.
I must jump in. I am intimately familiar with all of the very many judges that sat on the MAPA case and read it. It was the retention of samples and not the taking of samples. So that's a very material difference, because Kennedy and MAPA, which are the two cases which disagreed with the English court, are on retention of samples. In MAPA's case, they asked for the samples to be turned over and destroyed because there was an exculpation. So what my learned friend has just said is very different from what I said, and I just put that on the record.
Well, I want to put it on the record, right? And I can be proven wrong. I'm not perfect. I want to put it on the record that the taking of a sample, intimate or otherwise, from someone who has not been convicted of any offense, who has been charged, it is not justifiable in any democratic society. I don't know of any case in our jurisdiction that decides that that is the position.
Good.
I think we understand the...
And Mr. Chair, I must, because this is again reported, put on record that we have amended the DNA Act many times now. And the last government, in passing it with the support, in my support in the Senate, specifically passed the law to allow that. So I want to say that this turn of face as to what the law is or isn't from a political party, I consider to be very unusual, and I must put it on the record.
Members,
I just want to say, Mr. Chair, I have to say this. I am not bound, right? My position here is to assist a committee on what I understand the law to be. And when the DNA legislation was passed, I was not in the Senate, I was not in the House of Representatives. Unfortunately, that may have been so, but the position is, as I understand the law today to be, that is the position. I have a duty to indicate that.
Thank you, members. The members of the committee itself will have an opportunity in our private deliberations to address all these issues, and whatever has been said is on the record. Now, I want to invite Mr. Ruans, followed by Womantra, and then Member Dial Singh, before we go to the two entities that I would like them to address their written submissions. Thank you.
Thank you very much, Mr. Chairman. In my short contribution, I would like to address the initial concern raised by Senator Ramdeen, followed by the AG's concern about inchoate offences, and I'm going to try to tie it back to Senator Choate's concern about the effectiveness of registers with regard to reducing recidivism. And certainly, in light of a lack of data driving this new bill, the concerns about effect on communities and families raised by Senator Richards. I will take 2 minutes or less. This system, like the US system, is an offense-based system compared to a risk-based system. And we heard quite a bit already about the need for risk assessments. Unfortunately, the offense-based system leaves the actual risk level of offender and severity of the offense uncertain. As a matter of fact, having heard ideas about and suggestions about a tiered system as in New York, according to a 2012 study funded by the Department of Justice, it was found that the US tiered system does not accurately predict the risk of recidivism by sex offenders. And therefore, bearing in mind that one of the main purposes of this bill is to reduce recidivism, among other things, there is in fact a concern about the adoption of an offense-based system versus a risk-based system. And this deals with a concern perhaps raised by Senator Ramdeen, considering that the Honorable AG said that certain offences may be scheduled out, and the concern raised by Ms. Clark earlier about overreaching. If we are to adopt a risk-based system, then perhaps many offences that exist now on the bill would not be so made. And on that point of risk-based systems, tying it back to the Honorable AG's concern about the inclusion of in-quit offences, considering that the principal difference between in-quit offences and the main offences is the incompletion of, well, what we'll call the physical component of the crime, the degree of culpability would remain the same, and bearing in mind the mental components of inchoate and substantive offences are the same. And if the system is to be risk-based versus offense-based, then we are almost automatically going to capture those who may commit inchoate offences because they may have the same risk as those who may commit substantive offences. And on that further point, bearing in mind again, the 2012 study done by the United States, funded by the Department of Justice, the link between, or the lack of rather, link between registers and the effectiveness reduction in recidivism. One concern raised in that study was that the offense-based system was not driven by empirical data. And we have heard concerns expressed today, as well in our context, that there's a lack of data. And on that point, that raised a very important concern for us in civil society, and that is the effect on communities raised by Senator Richards. Our concern is that if certain persons from certain demographics or, better yet, geographical communities populate the register for several reasons, might that community itself attract a kind of stigmatization which will make reintegration difficult. And this is against the backdrop of what we think are the many purposes of bill, and that is reducing recidivism, but without a doubt preventing offending in the first place and stimulating reporting of it. And one small point to end on reporting, and was hinted by Ms. Clark earlier, and that is, bearing in mind that there appears to be, I don't want to use with tolerance, but accommodation of sexual offenses like incest within small knit communities, which in part drives underreporting. Considering now that your name, your surname was shared by the offender, and the list of factors to be mentioned according to Schedule 2, might that not be a further, I would say, disincentive to reporting? Thank you.
Thank you very much for a very good submission. I want to invite Mantra.
Thank you, Chairman. I wanted to revisit the issue of mandatory reporting, just to say that this specific provision has not necessarily increased reporting of sexual offenses against children. And in fact, women's rights organizations and service providers, including the Family Planning Association of Trinidad and Tobago, have consistently pointed out that mandatory reporting in some ways is counterintuitive to establishing an enabling environment for young people to access services in relation to their sexual and reproductive health. Because even though many young people are victims of child sexual assault, a significant proportion of our young people are having sex. And that is non-coercive sex, and I wouldn't use the term consensual sex because under our laws, children cannot consent to sex. But even though a child may be a victim of child sexual assault, young people, minors, children are having sex. So I just wanted to point that out, that mandatory reporting can inspire fear in young people who now don't want to tell adults or service providers that they are having sex, and also service providers are impotent to helping these young people, giving them advice. And so in a way, this could have the opposite effect of increasing reporting to there being even less reporting because of the stipulation of mandatory reporting.
Thank you very much.
Can I just...
I'd just like to pass over to my colleague.
Just to point something out, under the Romeo Clause in particular, just as an example, under the Children's Act, there is consensual sex amongst minors and exculpation for that basis. So, you know, we've got to be careful there. Can I just ask a question from the prescriptive side on the mandatory point? Does Womantra hold the view that a convicted person who was someone who was convicted by a court for failing to mandatorily report a sexual offense should not be on a sexual offences register? That's where the court has determined that?
Yes, I don't think those people should be included in a register. We support the coalition's position.
May I also just submit that there are a few things that were raised today. In fact, Honorable AG, you asked about how do we know when someone is reformed? And in fact, that actually sort of lends itself to a more important question, which is what causes offending in the first place. And until we effectively consider those risks, we are not actually going to be able to answer the question, how do we know when someone is reformed? And therefore, we then also cannot effectively create an environment that supports mandatory reporting, considering the fact that we are still barely understanding the actual nature of offense. Research would suggest that one of the predominant risk factors is, in fact, a history of sexual abuse. And so, therefore, there's this duality in which once victim who becomes perpetrator has been ignored in the system as a victim for many years and then is penalized harshly as a perpetrator. And in fact, with respect to mandatory reporting, there are alternatives that could be created, one of which is an anonymized system of reporting, whereby a person themselves does not have to actively take that role of reporting. This would also, I think, facilitate dependence of offenders to report, because that's one of the major issues, is that dependents actually are oftentimes economically or socially limited in being able to report in the first place. But also there needs to be a conviction that you are fully aware that something is going on and not just a suspicion. So for example, as a doctor or as a teacher, there need to be systems that support their mandatory reporting. As it is currently in the school systems, the teachers are constantly getting reports of abuse, and there's a very paltry response to it when teachers bring it up. So we need to also have some sort of evidence that the system can effectively respond to mandatory reporting before we talk about penalizing people who don't report. And this also comes to the question that Senator Richards raised of how do we take an immediate community response? And what I would suggest is that from the time an offender is discovered in a community, there needs to be proper educational programs and psychotherapeutic intervention or social interventions in those communities specifically. Because the reality is that oftentimes offenders are propped up by communities. So for example, religious leaders or the father of a child who is offending, these people are oftentimes supported by the community. So how can the community also be empowered to ensure that offenders are not protected, but are in fact brought to justice? And what does justice look like? It also has to include that rehabilitation. It has to include that holistic approach of not just putting somebody in jail, which we know doesn't work, but that actually looks at them as a person and tries to understand where did society go wrong and how can we improve what has already happened and prevent this offending from reoccurring.
Okay, thank you. I want to ask Womantra one question, and that is, what are your views on mandatory reporting? Are you in support of it?
We are not in support of registering people who fail to report, simply because there are not enough systems in place to support reporting in the first place. And until that is done, I don't think we can penalize people for not reporting.
And also to say that this position was supported by the Children's Authority. I believe in the former hearing, Children's Authority said that there needs to be proper support for mandatory reporting as well. So it seems to be a shared position.
Okay, thank you. I want to invite Member Dialsing.
Thank you, Chair. And I was very pleased to hear all your recommendations and, your suggestions that how we can carry this further. And part of my problem is when I'm seeing certain patients at our adult clinics, most, when we see them, we go back in time and you may see those persons have been molested as children. They have been abused as children. And when you go into that, you realize that, years after you've seen somebody in a psychiatric clinic, and you cannot go back and punish the individuals who did this act, be it a relative, a father, or whatnot. And those individuals, I had a case recently where the father is now in a new home with stepdaughters, and we are creatures of habit. And most likely, that father is going to molest those other children. Now, so we have to have a way where we can go back into the past somehow. Remember, you're getting an evidence from a patient in a psychiatric clinic, so that's the first, effect you have when people say, oh, that person might be crazy, mad, you can't take their evidence. But you have cases there, that person is saying something. You have an idea that persons in the past needs, will be still out in society. So we have to develop a system to protect those adults who were children who were abused. And we also have to get a system in place to get the persons who did the abuser. So what I'm looking at is, if those persons were in their homes, I wondered why their mothers never stepped up and reported. And you give a few reasons, that sometimes it is due to fear culture, sometimes it is due to financial gains. But you see, if we have 2,500 children, teenage pregnancy a year, we have to do something. And how are we going to get these people to report? Those mothers who encourage this are like maternal pimps. You have to get the mothers to be responsible. Being a parent is it's a privilege, it's a responsibility. When you look at the convention of a child, you have to protect your children. Therefore, this register, I think, if you put persons who fail to report, be it a mother, in this register, if you put doctors who fail to report it, and there are cases where doctors may be scared to report it, and I actually had a case where a doctor was presented with a child, a teenager, who was pregnant, and when the doctor said she was going to report it, the teenager took out the phone and showed a picture of Short Man, and Short Man was the boyfriend who was a gang leader with guns. So as Mrs. Mahabir suggested, violence, the fear of reporting is something you have to look at. So in that case, the doctor would be fearful. But if we don't have that reporting, we'll continue having this 2,500 teenage pregnancies a year. So we have to have something in place. And the suggestion is you have, that register should be there, Mr. Chairman, with the offenders, with an O tag behind their name, and the non-offenders, those like the mothers, the doctors, the social workers, with an N attached to their name. So you kind of categorize it. So right away, a mother will know, look, I'm in that list, but you would know offhand, the list is there because you have not really, you're not an offender, but you're there because you have not reported it. So this is one thing I'm looking at, having that failure to report, getting those caregivers to report it. Now, the other thing I'm looking at is how do we get the children to step up? Because about 80% of persons who are abused never come out to report it. Those are like hiddenness. 80% of persons really is in their homes too. It's homes. People in their homes are being abused by persons they know. So if you have a huge figure like that, how are you going to get the children to come out and report it? And I think probably it was a failure of our educational system, a failure of our parenting technique, a failure of our society not to teach those children there's the good touch, bad touch technique. And my suggestion is we have to have a way where as we teach children in the school the ABC, we teach them good touch, bad touch. The children will now come and say, Miss, I was touched badly by my father. Right away, the social workers could go and attack that case before it reaches a case of abuse. So I think as organizations, we have to see somehow if we could bring in this into the educational system. And Chairman, one other point I just want to make. The issue of doing testing on the victims. You have to do testing on the victims, because if you have a girl who, say a 15-year-old girl who someone has sex with, and you're now going to charge a gentleman, if you have to know the status of that victim before, does that victim have HIV before? Could that victim have gotten HIV before from another contact? Not necessarily this contact. So in terms of medical evidence, when we see victims of rape, we do testing both on the victims and also on the perpetrator. Thanks.
Thank you, Member Dial Singh. I want to invite Member Chote first, and then I would invite first Ms. Clark on behalf of the 4 entities to direct your attention to the 6 recommendations you've made in your submission, and to summarize in your closing for us any aspect of those recommendations that you've not already addressed. Then I would invite Vision and Mission to look at your recommendations and summarize for us in your closing any part of those recommendations we've not already addressed. Member Chote.
Thank you, Mr. Chairman. Perhaps I could get a view of Ms. Solomon on this issue. Having regard to the statement by Member Dial Singh that, certain mothers are maybe considered as pimps because they are not reporting while accepting the monies of the perpetrators of these crimes. I know that it's not only mothers who find themselves in that situation. You have grandmothers, you have older siblings, and so on. But is it your view that punishing these persons further by having them registered as sex offenders is likely to encourage reporting, or do you think that there is an alternative method that we can use to try to encourage reporting?
Thank you for the question. I think that it's an important question. And first, I think what I would like to say is that I completely support Ms. Robertson-Toney in her call for a nuanced approach. Not just a nuanced approach, but to understand the nuances of these kinds of situations. I think it is perhaps a little overstating the situation to say that mothers would be pimping out. That may be the case in certain circumstances, I don't know, but I think as a general statement, this is not helpful. I think you are correct in your question in suggesting that there should be other ways of encouraging reporting. I do also think that some of my other colleagues here have said that this kind of punitive approach tends to drive these things underground, and that is a very dangerous social problem. I think there are a number of structural issues that need to be addressed in connection with the propensity for sexual offenses, for sexual assault, and for the lack of reporting and the high levels of attrition from the system that are not necessarily addressed by the creation of a sexual offenses registry. And so to suggest that this can fix all of those issues is incorrect.
Thank you very much. Before I invite Ms. Clark to make the closing submissions, I want to just remind you, this is not your last opportunity. You have the opportunity to make any further submissions in writing to us. In addition to which, as I said before, the committee goes into meetings of the committee itself. And if the committee believes that there is need to hear anything more from you, the committee will give you an opportunity to come and discuss with us any other matter that we feel that you need to address. So your appearance today and your discussions with us is not your final opportunity. We understand that there may be things that you want to draw our attention to when you leave and when you discuss amongst yourselves, and you are free to do so in writing. And if you feel that it is something that we should hear, you can indicate to the Secretariat by email that there is a further matter that you wish to be heard on. So I invite you, Ms. Clark, first, and then Vision on Mission to make your closing submissions.
Thank you very much, Mr. Chair. I think the heart of the issue here for us is to be clear about what the objective of the legislation is. And as it is drawn, the objective seems to be, of course, to prevent recidivism and also primary offense. We think that to do that, we want to move from an offense-based approach to exactly what my colleague from WINAD spoke about, a risk-based approach. So how do we determine who is at risk and why? And we are saying that this has to be determined through some sort of evidence base, and it should be primarily a judicial decision. In other words, we should not have mandatory entry onto a register. We need a case-by-case approach, which will help us understand whether or not that person is at high risk or medium risk at reoffending, and therefore appropriate to go on a register with all of the curtailments of freedoms which are embedded in this proposed amendment. And so I think one of the things that we have not really discussed here is the question of how you enter a register, and we are really recommending strongly that this has to be a judicial exercise. We think that's important for not breaching separation of powers, and it's also an element of the due process rights of accused persons, that they also get a chance to comment, to be heard on sentencing, and the judicial officer has information before them that will give them some sort of objective basis in determining whether someone should go on a register or not.
Can I ask you a question, please? Sorry to interrupt, because I want to get it while you have it there.
Yeah.
I accept that one could argue the constitutional provision of separation of powers. I'm not troubled by it at all, because there are umpteen examples in our law from bail go down where these circumstances happen all the time. But I want to ask you a question. Insofar as you're going risk-based, nuanced, what would your view be if it was judicial, but in a reverse burden, show cause why it should not happen? One of the shortcomings of the last law was that the judge was supposed to do something which never happened for a full 18 years, 19 years now. So if you look at the Sexual Offences Act in the part that created this register, the judiciary had to take a step which allowed for reporting to the Commissioner of Police, and then the list would be populated, and then the register would happen. So clearly the judicial capacity and coordination between the police and the judiciary just didn't work. What would your view be, whilst you're on this topic, of if we were to look at page 25 of the bill, section 53, we have that clause that says a registered sex offender may be, on the basis of any compelling reason, applied to the court to have the information obtained in the register, contained in the register in relation to him expunged. So let's assume that we modified that and said, look, before it goes on the register, at X point in time, what would your view be if you were to say the person who is effectively liable to be put on that register should show cause why he should not be for some compelling reason? In other words, then, a bridge gap between the failure of the last law for a full 18 years, where the court had that exercising function and failed to do it, and this occasion where we say You're going on the register. You have an opportunity till you find yourself there to show the court why you should not be put there. In other words, then putting the onus upon the person who has been convicted and is still in the sentencing aspect.
I have to say I haven't thought about that, and I would need some time to think it through. But my first response, and maybe my colleagues may also want to jump in on this, is that I think entry onto a register, entry onto a register is further punishment, is an aspect of the sentence. Yes, you're convicted and you're also put straight onto a register. That's an aspect of sentencing. And I think, however, wherever you sort of enter that component of the sentencing, the court has to have some sort of evidence before it on risk. And there are tools, I understand, that are developed internationally which can be used there, lethality assessments and risk assessments, that you can make a sort of a decision that can be scrutinized and can be justified as to why you put someone on a register and for how long. And so all we're saying is let's go with some sort of thought process on it, which is based on what we understand about psychology and sociology before we put people on a register for quite a long time, and particularly if it's a public register, which of course we too are also thinking may not be appropriate, a fully publicly accessible register. So, yeah, I think whether the burden is sort of reversed as to prove you don't go on the register, or whether there's an assumption that you go on the register, a presumption of that, I still feel in any event there has to be some evidence before the court, some assessment before the court that helps the judicial officer make that decision.
Could you look at it and perhaps come back to us with maybe a note of further submission? So my specific question is, well, the position that I'm taking as the creator of the bill is the court found it good enough to convict you for an offense. Yeah. Let's forget the inchoate offenses for a moment and the associated aspects of mandatory reporting, which I didn't catch the Children Authority to say in the manner that was just suggested, but I understood what was suggested, the support services for mandatory reporting. So my position would be, could you please look at the circumstance where prior to going on the list, the accused would be invited to show cause why he should not go on the list. And maybe also where a complainant, a virtual complainant, or a relative of a virtual complainant, somebody with capacity, taking into account the minor issue, could also show cause why. In other words, that category of incest, where, for instance, there could be greater harm to the family in a publication of a list of that type. So could I invite your attention on a cooler occasion? You can send it in to us. I'd love to have the benefit of your thought on that.
Yes. I also think that my colleague has something to say on that.
Quickly, thank you, Mr. AG. I think your suggestion appears to be, at face value, a decent compromise in reversing the burden. All the reverse onuses, of course, bring their own constitutional issues. But if we reverse the burden, and which can invite, of course, a risk assessment, which we are suggesting, then the same reasons why burdens are not ordinarily reversed, those reasons might pop up. For example, who is going to pay or fund the risk assessment, and how would the defendant or the offender be so unable to access the services to present an argument that here's what he is of low risk and therefore is not deserving to be placed on the register. And in so doing, it highlights almost a kind of abdication of responsibility by the state. But even if not to that extreme, there's an issue of resources. And again, similar reasons why reverse onuses are typically not permissible. So at face value, compromise, it sounds great, yes, but there are issues as to how...
Could I just mark the spot on that?
Yes.
Section 5 of the Constitution says that it is entirely constitutional to reverse a burden, just one, and I know you know that.
Yeah.
And Section 2 is that if I'm listening to the recidivist, the rehabilitative, the need for psychological participation, I'm just throwing it out as a thought. It is encouraging to have somebody who is at risk of going on a system to want to work to demonstrate that he ought not to be or she ought not to be put on the system, and therefore it gives a sense of self-motivation. And then the third aspect is that the state of Trinidad and Tobago is notoriously bad at taking the first step in most instances. And I could say that as the Attorney General running the entire litigation portfolio of Trinidad and Tobago, that I think it's faster for an individual to want to not to get on a list, the same way it happens in other places, having that opportunity. So if you could think about it, but I accept what you're saying, but I'm looking at it now from a state management point of view as well.
Thank you.
Thank you. I want to invite the Vision and Mission. We have your written submissions, and I want to invite you to make any closing submission you want to make.
Thank you, Chair. I would just want to make a comment, and Mr. Husbands will go further in some detail in our submission and closing comments. With respect to the mandatory reporting that you've been asking about, we are not in support of that mandatory reporting for persons like teachers and civil servants, etc., who may be aware of an offense. They are not the offender. They have not committed an act. But what we seem to be doing is criminalizing their non-reporting. And from that point of view, there are the nuanced approach. There are a number of reasons why someone may be hesitant to report that crime. I'm not saying they should not report it.
Sorry.
But I'm saying, yeah.
Just to clarify the issue for the public, even though I understand what you're saying, the mandatory reporting offense exists in many laws, other laws, sexual offenses, Children's Act, etc. So there are laws that say you commit an offense if you don't report. This law is, and I just want to clarify in your response, please, if you could, this law says if a court convicts you in a matter where you had a mandatory reporting requirement for reporting a sexual offense, is it that you're saying that your position is don't put that kind of offender on the register? Because that's totally different from the requirement for mandatory reporting. The government does not hear anybody to be saying remove those laws, change the Children's Act, change the medical profession, etc., and remove the mandatory requirement. That is the law and has been for a very long time. So which is it?
It is putting them on the the register. Okay?
Thanks.
I think because there are many circumstances which may surround the situation, there is need to do more than just say you failed to report and therefore you should be on the sex register. There are systems, we need to put systems in place. A lot of these systems are inefficient and inadequate.
And quick other interjection. The people who procured prostitution, harbored prostitution, drugged women and had them, etc., those kinds of, they didn't commit the sexual offense, they didn't rape, they didn't abuse the child. What's your view on those people going on to a register?
Okay, I think we are speaking about two different sets of...
Correct.
Right? For those persons, there is an offense that you can identify that they have committed, and they need to be dealt with that offense. I'm speaking about the civil servant who, in the process of doing their job...
No, I got that. I'm asking now about, you see, if I, as the drafter of the law, to be clear, say, look, only the offender goes on the sex offenders registry. That's the person who penetrated, the person who raped, or whatever it may be. And if I say, take off the inchoate offenses, take off things like the mandatory reporter, because that person wasn't in the act in flagrante, right? If I draw that line, I now have to distinguish other lines. So I'm asking now squarely, as we draft the law, take, for instance, the pimp who drugged someone and had that someone being raped at that point, and a court convicted that person because there's an offense for that, or under the Trafficking in Persons Act, Section 21, where drugs were used, life-threatening, sexual assault happened, as in 21, should that person who did not rape, but who procured that circumstance, exploited, and framed it, should that person go on the register?
I think we agree that persons like that should be on the register.
Got you. Thank you.
Those who procure, those who pimp out, whatever you want to term it. But you understand the other
Thank you for the
category.
clarification.
Yes, so I just wanted to make that point, and Mr. Husbands will make some closing remarks and go further into some aspects of our submission. Thank you.
A very brief
yes,
closing
very
remarks.
brief. It's a very important piece of legislation, I must admit. I'm in total agreement with the registry. I think it lends a whole thought towards public safety. I always speak from a corrections perspective because I worked in the criminal justice system, and I see that it's part of offender management, particularly in community corrections. You must have some kind of regulations to monitor, to help support, provide care, surveillance, and supervision to help these people to live the right kind of life we want in the community. But most importantly, it's all about, from a restorative justice perspective, I haven't heard anybody talk about it now, the victims. What about the victims? What about the communities? We have to make our communities safer. We have to protect our innocent children. I am, for one, encouraging that we look at the whole gamut in terms of the interventions. It's not only about chemical castration, it's about aversion, in terms of aversion therapy, cognitive behavioral therapies, desensitization. All of these things need to be in place, not only in the community, but in the prison as well. And I'm saying we must take a risk approach. There are instruments that can be used in court, the probation officers, the magistrates and like, to ensure that the type of person we want on the sex registry are the ones that are going to be placed on the sex registry.
Thank you very much, Mr. Husbands. And I reserve the last say to Mrs. Mahabe Wyatt. This is a Senate committee. You served in the Senate. We appreciate all your hard work and contributions. And I give you the opportunity to present the final say for this afternoon's hearing.
Thank you, sir. Mr. Chairman, that is very generous of you and very kind. I do support, of course, all of the points which were brought up by our coalition, which we have all worked on. I am very appreciative of the many views that we have received from the Attorney General and for other members on the committee. They have been really useful. And the attempt that I have seen for people to find a way to make this work is very gratifying for those of us who work with adults who are sexually abused as well as children. My initial concern, which I will try to send in a written note about because it comes up so often, just to let you know why we can be concerned about to prefer the confidential and anonymous reporting is because, and I can give you one actual case that I was dealing with not too long ago, where it was a grandmother who came to me. Now, she could have been regarded as a virtual complainant, but why her daughter, who was a mother of these two girls, one was 8 and one was 10, why the mother did not report them was because the father, who was abusing the children, told her that if you report me, I am going to kill you, and then I will be the only parent in charge of these two children, and I can do what I want with them. His description of what he was going to do and how he was going to kill her was one which they both thought was absolutely foolproof. Nobody would ever suspect him of having done it because she would have fallen off the roof balcony when they were up there doing whatever it is they normally do, which was of a nature of repairs, which she did very often. And she knew it could happen, and she knew he would do it. And therefore, she couldn't report it. She was too terrified. This is not a once-in-a-lifetime example. The fear that people feel, not just doctors, but I know doctors and nurses have expressed this to me as well, that they feel in a country which is a violent culture. We are a culture of violence in this country. And I think that we have to be very sensitive to that because all of the people who have spoken here about it being a deterrent to reporting rather than an assistance, I think have to be taken seriously. Thank you very much, Mr. Chairman and Mr. Attorney General. We do appreciate your attention.
Thank you very much. In closing, I want to thank the entities which have assisted us this afternoon: Coalition Against Domestic Violence, Caribbean Center for Human Rights, Child Welfare League of Trinidad and Tobago, Women's Institute for Alternative Development, WINAD, Womantra, and Vision on Mission. This meeting is adjourned to Tuesday, March 19, 2019 at 10 a.m., at which time the committee will conduct its final stakeholder discussions with the following entities: the Rape Crisis Society, Institute of Gender and Development Studies, UE, Organization for Abused and Battered Individuals, Women Working for Social Progress, Trinidad and Tobago Association of Psychologists, Caribbean Association for Feminist Research and Action, CAISO, Sex and Gender Justice, Trinidad and Tobago. And we've also invited the Office of the DPP, which was not able to attend at the previous hearings. We've invited the DPP, subject to availability, at the next hearing on March 19, 2019 at 10 a.m. I want to, before we close, the Attorney General has a question to ask.
Forgive me for just jumping back, but it's a critical issue that ties into the mandatory reporting. I took the opportunity to pull up the Sexual Offences Act on mandatory reporting, Section 31. And the offense is committed in this circumstance: any person who, without reasonable excuse, fails to comply. So it isn't a strict liability offense. You're the teacher, you're the parent, you're the person, etc. It's that the court considered that there was a reasonable excuse offered to you. Look, I fear death. The man told me he was going to kill me. I'm economically dependent upon the person. I'm the subject of domestic violence, abuse, all of those circumstances. So I just want, out of an abundance of caution, on the record to put out that this mandatory reporting thing isn't a strict liability thing. You saw it, you knew it, you didn't report it. That's not how it happens. You must fail to have a reasonable excuse for not doing as you did. Does that change anybody's point of view at all on the issue? And it's okay if it's no. No?
No, because there are very few people who are willing to go to court.
Got you. Last point. If a judge were to consider that issue in this nuanced, risk-based approach for the mandatory reporter, so convicted by a court of not having a reasonable excuse, if the judge said that that person was risky enough to go onto a sexual offenders list, would you be okay with that?
It would depend on risk about what? What would be the recipe?
Yeah. So in your further submission, Ms. Clark, as you're going back, just take that as my second question. Look at it if you've mentioned judicial consideration, and I've now pointed you to the non-strict liability aspects. Let me have your views if you don't mind, because remember, moving Parliament to amend laws is a process, and it's a 3/5 majority process. So that's why I've interrupted the smooth flow of the wrap-up to ask you just to have that final look at that for me, please, if you don't mind, because your views are so important. Thank you.
Thank you. I want to close by thanking the members of the committee for attending and for their contributions. I want to thank you very much. I want to thank the listeners and the viewers and all those following this discussion. Thank you very much.